Welcome to the Kessler Law Firm podcast. If you'd like to connect, you can find the link to our website along with directions to our office in Fort Pierce in the show notes of this episode. Attorney Michael Kessler has been providing criminal defense and protecting the rights of citizens on Florida's Treasure Coast since 1985 and has been designated by the Florida Bar as a board-certified criminal trial specialist. With a solid record of success spanning over 40 years, attorney Michael Kessler has proven that more people are wrongly arrested for drunk driving than any other crime on the books. And now, here's Michael Kessler.
Hello again, everybody. Let's talk about court. One of the questions I keep asking is, how many times am I going to have to go to court and what for? So let's walk through that again. The first one is called arraignment. Arraignment is a formal proceeding that you're probably not going to attend. At an arraignment, a judge in Florida tells an accused person, this is what you're charged with by the office of the state attorney. Do you understand? If you say no, the judge will probably take out the statute book and read to you the definition of the crime with which you're charged, and then ask you again. If you say no, I don't understand, again, sometimes the judge will read the same thing, just louder and slower. At any point, sooner or later, you're going to say, yes, I understand. Judge is then going to say, you have a right to be represented by a lawyer. Do you want to hire a lawyer? You can hire any lawyer you want. Or would you like to apply for the services of a court-appointed lawyer, someone from the public defender's office, or perhaps the regional office of conflict counsel, or maybe even somebody on the wheel, a private attorney who accepts court-appointed cases when those first two offices are not available. Finally, the judge will ask, in response to the charge, how do you plead? You can plead guilty, which says I did it and I have no defense. You can plead not guilty, which says either I didn't do it or if I did, I have a defense. Or you can plead no contest. No contest says I'm not admitting anything, but I'm not denying anything either, and I'm choosing not to challenge or contest the charge against me. Now, if you plead either guilty or no contest, then you have to be sentenced, either right there on the spot or at a later date when the judge tells you to come back. If you plead not guilty, then the case gets sent on its way toward a potential trial. Now, along the way to trial, there are regular status hearings. These are approximately once a month, once every 4 to 5 weeks, depending on the individual judge's schedule. A docket call. Docket refers to the judge's inventory of open cases. So once every cycle, a criminal court judge will typically conduct a status hearing one at a time on every single case in that judge's open inventory. And the purpose of the status hearing is for the judge to determine from the parties who's ready for trial. If you're ready, if both sides are ready, or if the judge thinks you should be ready, the judge will schedule a specific date for jury selection. If one side or the other is not ready, then the judge will probably postpone the case to the very next cycle. This is also a time when sometimes negotiated settlements are presented and accepted by the judge. And of course, sometimes cases are taken off the docket because they've already been resolved either through dismissal, trial, or settlement. Now, in Florida, if a person is already represented by an attorney, the accused person doesn't have to show up for arraignment. The attorney can go in their place, or the attorney can simply waive the arraignment altogether by filing a not guilty plea in advance in writing. Similarly, for a docket call, an accused person doesn't have to take the day off work or off fishing or off shopping or sleeping or whatever to go to a status hearing if the case is not going to be resolved or scheduled for trial. Florida law allows a defendant, an accused person, to sign a written waiver of his right to appear for that court appearance. My office policy is if I don't need my client there with me for scheduling purposes, then I would just soon have them sign a waiver and go about their business, and I'll handle the docket call without them. And I tell them that at the start of the case. If you want to come to docket call every month, of course you're welcome to. Um, but not much happens, and it's a lot like going to court and sitting around and watching the carpet fade. But that's all right. It does give some people a comfort level. But if you've got better things to do and your case is not going to be resolved or set for trial, then you can just sign a written waiver form that we would send you, sign it, send it back, and we'll file it before the court date. I still need to go to court, but you won't have to. Typical docket call your part when your case is called will last a matter of seconds, almost always less than a minute. But you could be sitting over there in court for a couple of hours waiting for your case to get called. Some of our felony dockets on the Treasure Coast in Florida are still very much backed up from when we had no trials during the COVID period. And it's not unusual to have a couple of hundred cases on a judge's docket. So if you're the oldest case, you get called right away. If you're one of the newer cases that managed to be on the docket already anyway, well, you may wait. Judges also call their docket in a variety of different ways, some by case number, oldest case first, some by who's in jail before who's not, some alphabetically by the name of the defendant, and some alphabetically by the name of the defense attorney. I don't know any judges that call cases alphabetically by the last name of the prosecutor. Of course, there are some cases that get called out of order if, for example, a high-profile case is being handled by lawyers who don't regularly appear in this courtroom. A judge may call them first and get them out of the way. Similarly, if a high stakes case has to be specially set for an extended period of time, a judge will typically call that early in a docket call so that the judge can put that on a particular calendar, take up those days, and then set things behind it as backups. This is also a tool that the judges use so they know, well, how many cases am I setting for trial next week? Because that tells the judge, well, how many potential jurors do I need the jury clerk to summon for me? So to sum up, your case may go through a whole lot of docket calls, but you're not going to have to attend. Now, how many docket calls it takes? Well, that depends, gosh, on the kind of a case it is, the judge it's assigned to, how complicated the case might be, and also the venue or the place where the case is set. For example, for a large chunk of my career, the two county court misdemeanor judges in Indian River County would expect a case to be ready for trial the very first docket call. Some defense lawyers grumbled, speculating that this was because neither of those two now retired county judges ever represented an individual client and had to get a case ready to defend. Both of those gentlemen were former state attorneys, career state attorneys. And so the police got their case ready before the person got charged. In any event, it's unusual for a case to go to trial the first time up unless both sides want it to. For more information about your case and the scheduling that might affect your life, give us a holler. Our phone number is 466-4900. Of course, that's area code 772. And you can find us also at www.kesslerlawfirm.com. See you at docket call.
Thanks for listening to the Kessler Law Firm podcast. If you'd like to connect, check the show notes of this episode for a link to our website and directions to our Fort Pierce office. Whether you're watching this on YouTube or listening to it on your favorite podcasting site, please click subscribe or follow so next time you come back, our podcast episodes will be ready and waiting for you.